Parental consent for minors' abortions hits a legal roadblock. The Supreme Court has just delivered a significant verdict by dismissing an appeal from Montana's legal authorities who wanted to reinstate a state law mandating that minors must obtain parental approval before undergoing an abortion. This law, first introduced in 2013, but never implemented due to ongoing legal disputes, was supported by state officials on the grounds that parents should have a say in their children's medical choices. However, the Montana Supreme Court ruled against the law last year, deeming it incompatible with the state constitution. This includes a fundamental clause that recognizes the rights of minors. Justice Samuel Alito, known for his conservative stance, expressed agreement with the court's decision to abstain from reviewing the case. He characterized the appeal as a poor vehicle for the court's examination, though he did provide a nuanced acknowledgement of the legal arguments involved. Fellow conservative Justice Clarence Thomas joined Alito's perspective. The Montana officials argued that the Montana Supreme Court's ruling contradicted the parental rights guaranteed by the 14th Amendment of the U.S. Constitution, especially the right of parents to supervise their children's medical treatments. Here's where it gets interesting. The Montana law stipulated that any minor wishing to have an abortion must either secure parental consent or seek a judicial waiver under specific conditions. The state's highest court emphasized that a minor's authority over her reproductive choices ranks as one of her most critical rights. The justices also pointed out that the state failed to demonstrate any compelling interests that would justify overriding these protected rights. But there's more to the story. Unlike many Republican-led states where abortion access has become increasingly restricted following the pivotal 2022 Supreme Court ruling overturning Roe v. Wade, Montana stands out by maintaining broad abortion availability. Notably, the Montana Supreme Court has consistently upheld abortion rights under the state constitution. Additionally, voters in 2024 solidified this protection by approving a ballot measure that reinforces the right to abortion. So here's a thought. There's a nuanced tension between state and federal rights on this issue. How do you perceive the balance between parental authority and the rights of minors when it comes to reproductive health? Share your thoughts. Do you think the Montana decision provides a fair approach to balancing these crucial rights, or does it require further legal consideration? Feel free to voice your opinion in the comments.